I've been requested by Mr. Sanjay Parekh to clarify something. Yesterday, regarding that Article 357 issue, I had said, for his arguments, I had given a clarification. He felt that I shouldn't convey the impression that he tried to mislead the court. He said that was his interpretation.
I mean, he appeared before us every day. We would never make that.
I said, of course,
probably just
I would clarify.
I mean, all that fine print, sometimes this happens, but that's all.
No, I want to say, my lord, I want to say something. I want to say, I looked into and sent it to Mr. Gopal Shankar Narayanan.
We'll never make that assumption about
No, not that, my lord. I say so. It's a question of interpretation. And I still feel that 357 doesn't exist. That's my impression, but I don't want to interfere now. I'll say so, my lord.
Mr. Gopal Shankar Narayan have to resolve this over coffee or better by the...
It's a question of interpretation by Gopal Shankar Narayan, interpretation by me. All that I wanted to say. I'll make it good, my lord, when my turn comes. In the rejoinder, I'll take 2 minutes.
The broader whether 357 is there and it doesn't change the...
Yeah, that's correct.
Side or the response on the other side.
Yeah, that's correct. That's all.
We seem to be at odds with each other.
I seek your lordship's indulgence.
Yes, Mr. Attorney.
For a small internal arrangement between us, and since the need for a historical narrative and a part of documentations to be read through, which I don't propose to do, and placing certain propositions in the context of historical narrative, we have divided job with solicitor and myself. What I propose to do is just to flag the lordship's consideration a summary of my written submission. I have my written submissions, but I want to place a summary just to take the court to what.
Summary,
yes, it's available in my.
Who you are appearing for, likewise for the solicitor. But as a matter of bifurcation, both of you would be appearing for the Union of India, right?
And Jammu.
All right. And so between the two of you will be appearing for the Union and the state. The rest are all for interveners, Mr. Dwivedi, Mr. Giri, Mr. Salve, Mr. Jetmalani, then Guru, and Mr. Nataraj, you will be appearing for the Union? Okay, but then all right.
Subjects are bifurcated, there won't be any repetition.
Like Mr. Banerjee also appears for whom? Vikramjit Banerjee as ASG appears for whom?
Vikramjit also would be allowed for the Union.
Can we then suggest one thing? If something remains, then that can be covered because we need not then.
Whatever timeline is given, they are our timelines, and it is always subject to your lordship's final call.
So after we complete with the first two arguments, we'll realize what canvas remains. Then I think.
But I just thought after you have taken and the attorney has taken 2-3 days. Whether Mr. Banerjee will require 1 day to argue for what would be a...
No, he didn't say 1 day.
Oh, it says 1 day. That's why we were...
1 day. That's what I mean.
One day. On part of my colleague. No, I'm sorry. It's a mistake on part of my colleague.
So Nataraj is 1 hour and he is 1 day. So I was wondering...
No. That is also 1 hour, but
all right.
That is outer. Kindly correct it, Manoj. That's a mistake on our part.
All right. Yes, Mr. Attorney.
Maybe as we travel along, days can become hours.
I'm sorry, your lordships.
So that we broadly know, and I'm sure after you people have finished, they will see whether they want to add something or not.
Before I begin reading my brief summary.
Summary of letters.
Lordships could locate it's in the written submissions folder. It's titled Summary of Written Submissions. Just a 2-page document. But before I do that, I must certainly thank all my esteemed colleagues on the petitioner who brought in a lot of very insightful understanding of this emotion, passion-ridden issue and complicated from many angles. And we tried to bring our own, if possible, keeping in mind the objectivity as well as the neutrality which is to be involved in understanding this. And some American historian said objectivity is not neutrality. Therefore, sometimes these things can become problematic. So, keeping in mind, and I'm also reminded of a very famous statement made by Abraham Lincoln in 1864 in response to a border territories conflict issue. He talked about balancing the nation, losing the nation, and preserving the Constitution. And he said, by general law, life and limb must be protected. But yet often a limb must be amputated to save a life, but a life is never wisely given to save a limb. I'll place that very full extract of it later on. For balancing between losing the nation and preserving the Constitution. Which will be my running theme in trying to say, we want to say that Constitution will be preserved in the context of the processes, due processes, the fairness of the processes, and how these procedures are important for the integrity of the Constitution on the one hand, and losing the nation on the other hand.
Equally, Mr. Attorney General, we can't postulate a situation where the ends justify the means also, right?
I know about that, but
means has to also be consistent with the ends.
We all of us understand that. So very often this question confronts all of us, both in personal life, public life, the politics of the nation, the dynamics of the political process, and so on. But then that is a question which definitely confronts. So how do you find answers which will probably produce the most sensible solutions? So let me try to read this summary. No factual or legal foundation. Your Lordship, please.
Is that what you're reading? Or
The
summary of it.
Summary.
And copies. Copies we have written. Yeah. New copies we have written. This side. This side. It is there. You mailed it. Lordships do not have it. Can I hand over a? Rogers Cowell has got that page. Well, may I proceed to read?
Yes.
Yes. No factual or legal foundation for any sovereignty argument. On a combined reading of the instrument of accession and the proclamation, followed by adoption of Article 370, all trace of sovereignty, if any, were surrendered and disappeared. The constitutional integration process of the state of Jammu and Kashmir with the Union of India, howsoever sought to be brought about, were the only object of Article 370. All principles and procedures pressed into service for the above purpose will always be considered subservient to this purpose. The power and deliberation authority of the President under Article 370 to deal with it in any manner is neither lost nor removed by reason of its exercise over a period of time, nor it can be said that the provision erased itself without intervention by any positive lawmaking power. Article 370 was conceived and designed to aid the constitutional integration process on the same line as it happened with other states. Its continued exercise over a period cannot be seen as a cloud over or a distortion of its original purpose. Any discretion exercised beyond its original purpose, seen as introducing room for whittling the constitutional integration or otherwise, can always be deliberated upon to bring about any changes in its contents or its abrogation. All judicial pronouncements in regard to Article 370 must be seen in that context as the challenges and claims placed before the court and their total view to be kaleidoscopically seen. Border states are a special class of territories of India, and their reorganization in Article 3 will deserve distinct consideration. The court will defer to the wisdom of Parliament in the choices of action relating to border states. The justiciability of decisions taken to deal with matters relating to border states may not be, as in the case of general run of reorganization of states or imposition of President's rule. The scheme and architecture of Article 356, which provides in regard to the sustenance of the fabric of the nation, will not be narrowed or compressed. The in terram argument demanding course correction or linearly tailored and need not be touchstone for ex ante tinkering in the undefinable state necessity potential of Part 18 of the Constitution. All instruments in aid of discharge of duty under Article 355, including the preamble to the Constitution, will be comprehended in the plenary power of Parliament to engage in the reorganization scheme under Article 3. The plenary power to act under Article 3 is available even during rule under Article 356. Long-standing or similar measures in regard to reorganization are not precluded. The availability of power is distinct from any due process. A. Neither asymmetrical federalism nor any other federal features have been infringed. We'll try to make good all these arguments. No rights in relation to representative democracy have been taken away. Reorganization of states includes temporary or other rearrangement of rights to serve the integrity of federalism and the unity and integrity of the country. All rights are available for exercise only if unity and integrity are intact. The doctrine of necessity is flexible. The long history of internal disturbance, lack of availability of real measure of rights and justice are matters that can be legitimately taken into account for paving the path for due course rearrangements. No person can have a vested right in favor of a perennial state of unrest, and all instruments of law which have not subserved peace and justice have no inherent justice right to continue to exist, to right to exist or to continue. However, it is submitted that all measures taken are within the due processes granted and to be pressed into service to act in exceptional circumstances. All steps taken under so-and-so or within the standard set of provision issued during President's rule and nothing arbitrarily designed has been provided for. All arguments and fraud and power are therefore misconceived. That's a broad summary of my submission. Just before the solicitor takes over, as part of the paragraph 7B, the last few sentences, I looked into all the presidential proclamations, running into 120 of them, and particularly in regard to Jammu Kashmir. The suspension of provisions of Article 3, the two provisos, and various other provisions of the Constitution of India, or in terms of a convention that the presidential proclamation follows. So no deviation has taken place as far as this particular presidential proclamation is concerned. So suggest therefore either a fraud on the Constitution is completely misconceived. I'll try to make good arguments referring to the documents. So I just want to play this summary to show that the due process has been followed. There is no deviation from due process. falls within the legitimate aims and objects of what the two orders sought to achieve, and the Reorganization Act also falls within the.
Thank you. Thank you very much, Mr. Attorney General. Yes, Mr. Sul.
Greatly, Your Lordship. But as indicated by the petitioners, my lords, your lordships would be taking a historical decision, my lord, in more than one ways. But first, this is for the first time, my lords, after 75 years, that your lordships would be considering that the privileges with which the residents of Jammu and Kashmir have been deprived of till then, till date, have been conferred. And I make this submission good, that so far, Article 370 function as a detriment between the welfare scheme flowing from the center, the constitutional right flowing from the center, and the residents of Jammu and Kashmir. But second thing, but because of this confusion, whether it is temporary or permanent, there was a kind of a psychological duality which was in the minds of one particular region of our country, though since inception of the constitution, it became part and parcel of inalienable and integral part of India, but there remained a psychological duality, whether induced or otherwise. That, my lord, your lordships would end. Judgment going either way, my lord, that position would end. And third, my lords,
Mr. Solicitor, the first one, can you just in a sentence again formulate it? I somehow missed the first one.
yes. Lord, your lordships would find at the end
I
of.
don't want to interrupt my learned friend, Malat, but the new volume has been added. 2 new volumes have been added, which were not there before, 2 days ago. I don't know, Malat. I may be wrong. I have no objection, Malat, but I just want to point that out.
It was added with the permission of the court before 6 days.
It was added, that's all I'm saying, Malat. The written submissions are new. I will not object to any of that because I don't believe in objecting to materials which are relevant for the court.
No, that's
Since the court told me.
permitted. We mentioned your lordship.
I'm not disputing, you may have mentioned. I'm just saying, Malat. I have still no objection, Malat.
Volume 3 are your submissions, Mr. Solicitor?
What, my lord, your lordship, my lord, the Chief Justice would recall, Lord, what we have done is my submission, the submissions of the learned attorney, and my lord, all our submissions are placed in one volume. Our submissions, my lord, were new and detailed after, my lord, hearing them. And thereafter, my lord, in a chronological order and with continuing pagination, they form part of volume number.
On Monday, when the solicitor mentioned in the morning, you informed us that the list of dates which has been filed by Mr. Sibal.
Yes, that is incorporated.
You are adopting the same list of dates, but where you are adding something,
yes,
you are putting it all together, so we don't have to flip between list of dates.
Written submissions are all new here.
This
Are all new. I'm not disputing. I still am not disputing.
I believe.
I still will not dispute, and I'm just saying, Malat.
Then let's start, my lord, because
I'm only saying, Malat, I was not allowed, that's all these are all new, but I don't mind, Malat, we'll answer.
What we had, when he mentioned on Monday morning, I think we asked him whether your notice has been given to everybody, and solicitor said yes. At that stage, I told the solicitor, instead of having 5 different list of dates, work on the list of dates which Mr. Sibal has submitted. I'd also mentioned it in the course of the hearing.
That's right, sir.
And in that list of dates, add what you are adding separately so that we know what has been the addition by the Union of India.
Not only that.
All of us have one master list of dates. That becomes much easier.
I don't know.
It would have been better if this objection would have been raised. Because these. Let's not,
Sorry.
my lord, people are watching, let's not be, my lord, school children like objections, my lord. It was given on that very day at night.
No, it's because the
Not
court
right,
Apart from that,
not
please
informed.
hold your
A
tongue.
document is created on 24th August, which is today. The PDF says it's created 24 August. So I don't know how it would have been mentioned.
Mr. Prasanna,
Anyway, Malad, I think that we should go on with the hearing. I'm not objecting.
No, let's say.
you object and thereafter you are saying I am not objecting.
Because I was told that I should not be able to add anything. I had only put some, just
No,
5
no,
pages.
whatever is,
Mr. Burr,
assuming that
your submission also, it would have resulted in many more people.
That's why, Malad, I didn't press it.
I don't think we should go on this.
But even that has been taken note of.
That's all I'm saying.
Mr. Gopal Shankar Narayan was here from day one. He could have told us, but my lord, I must make a positive statement. Before we mentioned before your lordships, the previous night, this was placed on record with a service to all. They were aware and my lord, they knew that this is the master list of dates which all of us on this side will rely upon.
But Mr.
May I clarify?
One second. Mr. Solicitor, on your master list of dates, I hope you have maintained the integrity of the original list of dates.
Yes.
Where you want to add something that you have indicated to us in a separate note or separate color or track change.
What I have done, my lord, I believe at the outset that it seems my list of date contains something because this first objection appears to be the best point now after my lord, this list of dates. But leave it at
No,
that.
Mr. Solicitor, the reason why we ask you is, when one sits down to dictate the judgment, I hope in the list of dates, we will know what is Mr. Sibel's part and what is your part. So long as that is there, it's no difficulty for us.
Come to page 1 of my list of dates.
So long as it is there, we accept your word for it, but so long as your juniors have prepared it in that way, there's no difficulty.
Mr. Sibel, only a minute. Mr. Sibel's submission are incorporated in that general common list of dates in italics in blue color, saying KS means that's the list of dates of Mr. Sibel.
And whatever you wanted to add, you've added in a separate font or whatever, then there's no difficulty.
Nobody has any issue with the list of dates. It's just that if you are filing something, they should tell everybody. What has been done today is there are 107-page list of dates which is filed.
Mr. Prasanna knows everything was served. You please tell you, this is what a nodal counsel is supposed to do.
Yes.
So please a moment. The learned solicitor's written submission, apart from the list of dates, has somehow ballooned from 18 pages to 139 pages of, and a lot of it in very fine print. Now, I mean,
I'll put it the para.
Airdrop 3 minutes ago, 5 minutes ago, I got it on airdrop.
Huh?
So,
But from Mr. Prasanna, not by me.
if you're, nobody, when Mr. Sibel says he has no objection, yes, we are this.
But from your nodal counsel, he gave you date, my lord.
Yes, may I clarify?
We can.
Mr. Prasanna is trying to say something for last 5 minutes.
Yeah, Mr. Prasanna.
Yes.
My lord.
Just 1 second. Let's have a word from the young junior
It
here.
was certainly served last week, Your Lordship. I had not been informed that it had been allowed by the court, which is why I could not circulate it forward. So that was.
So
It was uploaded on Sunday night. Your lordships can check up now. Everything, my lord, is possible to be ascertained and verified.
So say that it was emailed to him on Sunday night with a copy to Mr. Prasanna.
Yes, my lord.
Yes, that's correct. That's
In fact,
correct.
we should-
It was
I
not
don't want to
circulated
find
because
fault
it had
with
not
it.
been
It's
allowed
not
by the
fair.
court. That
It
is
has
not something
come.
that I had been informed that it had been allowed by the court. That was where the case is.
My lord, my first point, my lord, why your lordships, my lord, judgment is going to be a historical judgment is this. A, my lord, after going through, my lord, the facts which we will point out on this side, your lordships would be satisfied that large number of fundamental rights and other rights will be now conferred upon the residents of Jammu and Kashmir. And they would be fully at par with rest of their brothers and sisters of this country.
Yes.
Lord, number two, Lord, because of, I'm sorry.
Yes.
because of the ongoing confusion, which according to us there was none, but because of the ongoing confusion whether this provision is temporary or it has become permanent, etc., there was a psychological duality amongst the minds of the residents of Jammu and Kashmir, and that was being taken disadvantage of by, I would say, my lord, interests not inimical to India. That would be settled once and for all, whichever way your lordship decides.
Yes.
Now, my lord, I'll take your lordship, my lord. I must, my lord, assure your lordship that yesterday we undertook an exercise that your lordships have been appraised with almost everything, my lord, on facts. But your lordships are specifically not appraised with many things. So, my lord, in my list of dates also, we have, my lord, marked which portions we would not trouble your lordships by reading. So kindly directly come to, my lord, in that common compilation, page 6, PDF page 6. So this is only for one reason, my lord, I am reading this part. My Lord Justice Gawai was pleased to put a question. There was a Praja Sabha constituted, your lordship would recall. And my lord's question was, what was the composition of the Praja Sabha? No, that is what is mentioned. Your lordship would find the second date, my lord, on this page is 20.
Just only one thing, Mr. Kanu Agarwal. I'm not asking the solicitor this. In the list of dates, there is some dates which are marked by the light brown.
Yes.
One by green, one by blue, and
please come to page
so
4.
is there a distinction for our
Please
purpose
come to
between
page
is there a like green, blue?
It's a legend. Page 4. Page 4 will be the answer.
We just want to see
Page 4.
Then we have clarity, you know.
This is one of the color scheme which we have used.
All
History
right.
of Kashmir is this color.
All right.
Then British events, law and statements.
Agreed.
Then blue will be Indian constitutional history. Red will be process of integration, etc. This is the relevance of the color.
Right.
But your lordships need not, my lord, bother about that, my lord. Once
All right.
the flow I have kept chronologically. So therefore, colors might keep on changing depending upon the legend, but the flow will continue.
And where you say KS in italics, that is Mr. Sibbal's original.
Fair enough.
Mr. Got it.
Sibbal's submission. Therefore, your lordships may consider not keeping Mr. Sibbal's submission side by side. It contains everything verbatim.
It's much easier.
As my lord produced before your lordships. That's all I wanted to show. Date 20th of April 1927. I'm not reading it, but this is Mr. Sibbal's submission in his list of dates, and I have not missed, my lord, any date from his submission. It is in blue color and in italics. The next date is 22nd April 34. Maharaja Hari Singh enacted 1934 Constitution of Jammu and Kashmir. This law established a legislative assembly called Praja Sabha, which was to function under the supremacy of the Maharaja. Lord, answering my Lord Justice Gawai's question, the Praja Sabha was to have 75 members, of which 12 would be officials, 33 elected members, and 30 nominated members. Then, my lord, rest your lordships can consider skipping, my lord, and kindly come to, my lord, 7. Just, my lord, taking your lordships chronologically, your lordships have seen this provision as well. I am just, my lord, refreshing your lordship's memory without reading the provision. Lord, this is a part of Government of India Act 1935. Lord, why it has become long The relevant parts are quoted for your lordship's immediate reference. My lords may not have to go through volume 1, PDF page, so and so, but page numbers are also mentioned, my lord, if your lordship would like to go through. But please see, my lord, at page 8, section 6 of Government of India Act 1935. Accession of Indian states. A state shall be deemed to have acceded to the federation if His Majesty has signified his acceptance of an instrument of accession executed by the ruler thereof, whereby the ruler for himself, his heirs and successors, Lord, declares so and so, so and so, so and so. Lord, the purpose of showing this is to, my Lord, point out to your lordships, and ultimately I'll assist your lordship with that proposition and one or two judgments on this. The moment the accession is complete, the sovereignty gets lost. The sovereignty is subsumed with the bigger sovereign.
Yes, sir.
There is a Privy Council judgment and few other judgments also, Lord, which will, Lord, take a little later on. There is one trivia, Lord, I have just added it. It doesn't make any difference for either of us. But as, my Lord, we attribute the Indian Penal Code to Lord Macaulay, Lord, this entire exercise of 1935 Act was done, my Lord. He was the author virtually of this, my Lord, Sir Samuel Hoare. One of the unsung heroes, my Lord, in the history of Indian partition, but it was he who drafted this. It has no bearing on the main question. Then, my Lord, I have reproduced the...
Actually, Mr. Solicitor, you may also read section 5.
Yes.
Because what is the importance of accession? That section 5(1) gives us.
Yes, I wanted to read,
Just
but I thought your lordships may have read.
No, but we need to highlight that
5,
because
page 7.
It shall be lawful. They just read that only that.
It shall be lawful for His Majesty, if an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as from the date therein appointed there shall be united in a federation under the crown by the name of the Federation of India. A, the provinces hereinafter called governors' provinces, which were under the direct British sovereignty or suzerainty, as the case may be, were functioning through the Governor General. Then B, the Indian states which have acceded or may thereafter accede to the federation, and in the federation so established, there shall be included the provinces hereinafter called Chief Commissioners' provinces, not the smaller regions which eventually...
The consequence of an accession under the Government of India Act was that then the acceding, they would be united in a federation.
In the federation.
The key words really in 5 are united in a federation.
In a federation. So, that is the first stage of losing sovereignty. The moment you sign accession and it is accepted.
But you'll have to at some stage deal with the argument which they have urged that sovereignty itself has an external component and an internal component.
That
external component was lost, internal sovereignty still remained. That's the
argument, my Lord. We are conscious of that. And, my Lord, I'll also bear in mind your lordship's very, very pertinent observation that ends may not justify the means. I'll also show to your lordships the means adopted strictly within the constitutional parameters and as per various judgments of your lordship. But that's, my Lord, after, my Lord, the factual chronology. Thereafter, your lordships, my Lord, kindly come to page 9, 1939. But this is also crucial. The Indian National Congress's formal stance was that the princely state must join independent India on the same terms and with the same autonomy as the provinces of British India, and with their people granted responsible government. As a result, it attempted to insist on the incorporation of the princely states also into India in its negotiations with the British. So we were, as Lord British India also, our leaders were already negotiating that princely states should also come at par with the provinces, British provinces, which were already under the suzerainty or sovereignty, as the case may be, of the British. Then, my lord, 7th September 1939, Jammu and Kashmir Constitution Act 1939 was issued by Raja Hari Singh. It established a council with a prime minister. Lord, why, my lord, I'm reading this, my lord, I'll just paraphrase this argument. Lord, why I say this? Lord, substantial arguments, my lord, were made that there were no constitutions. Jammu and Kashmir had a special place in the geographical British India because that was the only part which had its own constitution in 39. Lord, that is factually incorrect. There were 62 states which had their own constitutions. Whether they are named as constitution or any instrument of governance, internal governance. I'm just trying to show that the argument that Jammu and Kashmir had a special status from the beginning, which continued till date, is factually wrong. The foundation is wrong. And 286 states were in the process of framing that constitution during this period of late 40s, late 30s, 39 onwards. As a matter of fact, the eminent councils of the day, those days, were, my lord, engaged to help the princely states to draw their constitutions. I'm not going into that detail, that's not relevant, but one of the, my lord, when we researched this, Alladi Krishna Swami Iyer, who was considered to be one of the top ranking councils, was engaged. His fees were not found to be, the problem was there at that time also. By one state called Rewa in present Uttar Pradesh, I'm sorry, Madhya Pradesh. And therefore, my lord, he was requested not to continue because it was found to be too exorbitant. My lord, please see, my lord, from where do I get this? My lord, PDF volume 16, document volume 16, I'm sorry, document volume 16, PDF page 574.
Document volume
16.
Lord, this is a research paper by a very eminent professor of Yale. He has, my lord, done at 584 directly, my lord, because this is history. I may not, my lord, trouble your lordships beyond a point, but 584. The running page would be 10514. Lord, as a matter of fact, some of them made their constitution and thereafter immediately signed the accession also. And I'll also show to your lordships from this chronology that the draft accession agreement was common to all. Everybody has signed the same draft. I'll come to that. Please, my lord, see the second line. However, at page 584, my lord Justice Khanna and my lord Justice.
Yes, I got.
Yes, my lord Justice Call has that. However, the inauguration of Shahpura Constitution did not prevent the prince from signing the next day the instrument of accession to the dominion of India in 3 areas of defense, external affairs, and communications, as many other princely states did at the same time. Lord, next para, kindly come, Lord, some 5th or 6th line from the top of the unnumbered second para, Manipur. Your lordship would find Manipur. Does your lordship get Manipur? Manipur in the northeast adopted a constitution which on 26th of July 1947 provided for fundamental rights and separation of powers and recognized the Maharaja as its constitutional head. Maharaja of Patna declared the setting up of a representative constitution making body on 24th October 1947. Just as at the moment when the first draft of Indian constitution was ready, that same month, M.R. Jaikar, until the previous May, a member of the Constituent Assembly, advised Gwalior State Constitutional Reforms Committee not to depart in their proposed constitution from the model now in vogue, for instance, at Mysore. This pattern of general steps towards constitutions based on principle of representative government was repeated in numerous other princely states. These included Ond, Banswara, Bauni, Baria, Baroda, Barwani, Banaras, etc., etc. My lord, the list goes on and on and on. I'm not reading it because the names are not relevant. And this is whole length and breadth of the country. They were making either having their constitution or making their constitution. My lord, why? I just, my lord, we were just, my lord, examining why these three subjects are kept, my lord, even by them to themselves, my lord, namely defense, communication, and, my lord, foreign affairs. The reason was, answer. But there is a small princely state. It can't have its own army. Communication means the British had laid postal services and Britishers have also laid railway lines. So that communication was crucial, and every state can't have their own communication system for intra-princely state communication. And foreign affairs, my lord, obviously, my lord, they would like the greater power, my lord, to control. That was, my lord, basically the idea. Thereafter, my lord, as I go on, your lordships would be satisfied that ultimately everything started getting subsumed, and you know, there are discussions. Once Article 1 comes into force with first schedule, all states which became part of the first schedule, Lord, came to be governed by the Constitution of India, and the only sovereign which remained was we, the people of India. Now, kindly, my lord, come back to my I'm sorry, my lord, last line, last line. I'm so sorry, my lord. In that page 585, first para, last line. So far as we have traced, your lordship gets, my lord. It's somewhere, my lord, fifth line from the bottom of the first unnumbered para. So far, your lordship gets, my lord. So far, we have traced 62 states that framed their own constitution and 286 others that were involved in making constitutions for union of states, which shaped the new constitutional landscape. This fact has gone largely unnoticed in the study of India's constitutionalism. So, my lord, first, why I am pointing out the basic argument that Jammu and Kashmir was the only princely state having its constitution and therefore was getting a separate treatment is factually not found well founded. My lord, now your lordship, my lord, kindly come to my Lord, kindly come to page 10. Lord, your lordship, Lord, page 10 is a list of dates. Page 10 starts with Mr. Sibbal's note, my lord, which I have quoted verbatim. Then 12th May and 22nd May, your lordships may not, my lord, invest time in that. Kindly come the next date, 16th May, 1946. The cabinet mission planned by the Britishers issued a statement regarding its report. Under paragraph 15(1) and 4 of this statement, the cabinet mission plan recommended that Union of India, which should necessarily deal with defense, foreign affairs, and communication of princely states. They only recommended, my lord. In the, my lord, note of my learned senior, my lord, it is differently mentioned that it was decided. They only recommended. Lord, thereafter, my lord, page 11. Just a few weeks before becoming the vice president of the interim government, Jawaharlal Nehru clearly stated that no princely state could prevail militarily against the army of independent India. This is one of the first step for unification of the Federation of India, which eventually became Union of India. This is July 46. Then, 9th December 1946, Constituent Assembly of India was formed. But there is no dispute on this date. Lord, Jammu and Kashmir had 4 representatives, including late Sheikh Abdullah. But the relevant parties, when more and more princely states started acceding and accepting the Constitution of India, their representatives also kept on being added, and they started participating in framing of our Constitution. And, my lord, I will come to that, my lord, at an appropriate...
One clarification.
Yes,
the 4 representatives of Jammu and Kashmir were there from the beginning or only in October?
No, my lord, not from the beginning. They came, my lord, subsequently.
49, I think they came.
Yeah, yes. 49, my lord.
49?
It comes, so that date will come.
June 1949.
Yeah, yes, that date will also come. And I may, my lord, at the outset, my lord, just flag it. It would come in the chronological order. All these states who eventually became part of the Union of India had their differently worded instruments of accession. Some of them have said that taxation would be within our domain only. But thereafter, my lord, as the legislative and the constitutional history progresses, this is how countries are formed. When, my lord, we have more than one federal units, and it's unlike American federalism where they entered into a contract to form the union. We didn't adopt, my lord, that model in a very wise, my lord, foresight of our forefathers. That they did not choose that option. They voluntarily started joining and participating in the process of constitution making. Then, my lord, January 1947, Nehru, in his capacity as the vice president of the interim government, which included both present-day India and Pakistan, clearly said that independent India would not accept the divine right of kings. So this is January 1947. The stand of India and the party which led the freedom struggle was, we will not accept divine right of kings. We are going for a democratic setup. And that stand remained consistent, as I'll point out. Then, Lord, 22nd January 1947, Lord, the Constituent Assembly of India adopted objective resolution. Lord, my learned senior, my lord, read only one part, my lord, which is para 3. My lord, let me read para 3 and then rest of them. These were the broad, Lord, kind of objection reasons based upon which the Constitution was to be framed. Para 3. Declared that princely states that had joined the Union of India, whether with their present boundaries or with such others as may be determined by the Constituent Assembly, and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units, together with residuary powers, and exercise all powers and functions of government and administration, save and except such powers and functions as are vested in or assigned to the Union. Lord, the interpretation given by the petitioner was that the autonomy was the foundational stone of the constitutional making. Lord, this autonomy will have to be understood from the subsequent paragraphs. States are still autonomous in case of, Lord, list 2, schedule 7, etc. Lord, there are several provisions giving them an internal autonomy while being a part of the larger Union of India. Paragraph 4, my lord, this, according to me, my lord, should be read. Declared that all power and authority of the sovereign independent India, its constituent parts and organs of the government are derived from the people. My lord, the seeds of democracy born for the first time. That the sovereignty would vest in we, the people of India. Then 5. Declared that there shall be guaranteed and secured to all the people of India justice, social economic and political, equality of status. Kindly mark this. Equality of status was the above goal while framing the Constitution. One union or one segment of the Union of India cannot be deprived of the rights which are enjoyed by rest of the countrymen. Then 7, declared that there shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and law of civilized nations. And 8, declared that this ancient land attains its rightful and honored place in the world and makes it full willing so and so, so and so, so and so. Now, your Lordship, kindly see the next date, 25th January 47, the resolution for the establishment of the Union Powers Committee in the Constituent Assembly was passed. Lord, your Lordships can skip the next day. Lord, a statement by Clement Attlee, the then Prime Minister of Lord Britain. Then, my Lord, 17/4/1947, the first report of Union Power Committee was that is, my Lord, of the Constituent Assembly, was published widely, expanding the scope of phrases, defense, foreign affairs, communications, and powers necessary to raise the finances required. Further, the said committee further recommended in para 3 powers and subject which were inherent or implied or resultant from the express powers of the Union, that is judiciary, services, RBI, etc. It was also hoped that certain other subjects would be included in the Union list or that like insurance, planning, banking, patents, etc. Lord, this is the first report. Lord, the note of the petitioner, my Lord, which I have quoted, does not mention, my Lord, about this first report. They have directly gone to the second report. Therefore, my Lord, this has its relevance in the chronology. I have placed it, my Lord. Lord, second, the date can be, my Lord, skipped. Nothing turns on that. Constituent Assembly resolution appointing Union Constitution Committee, etc. Lord, 3rd June is an important date. 3rd June 1947. The legislative representatives of the Indian National Congress, the Muslim League, and the Sikh community came to an agreement with Lord Mountbatten on what has come to be known as 3rd June Plan or Mountbatten Plan. This plan was the last plan for Lord, all these facts, my Lord, would be necessary as a process of connecting the dots for me to, Lord, persuade your Lordships to reach a particular conclusion. Even otherwise, whichever way, my Lord, your Lordships would like to ultimately decide, these facts would be relevant, my Lord. Therefore, my Lord, I am placing only those facts which are relevant, my Lord, to the issue. Lord, now Mountbatten Plan comes. This is the only plan, Lord, for independent India, my Lord, last plan. The British government proposed a plan announced on 3rd June. My Lord, I'm sorry, Mr. My learned senior, Mr. Dwivedi points out that this resolution, which I say, my Lord, objective, Lord, was thereafter passed, framed and placed before the Constituent Assembly in 46, which was approved by the Constituent Assembly. And the preamble, my lord, draws inspiration from that one. The lordships have seen the words.
There was a lot of discussion also on that.
Yes.
Objective resolution.
Yes, my lord.
It was proposed by Pandit Jawaharlal Nehru.
On 13 December 46.
Dr. Ambedkar criticized a lot about that.
Yes.
He said that there are many things which are missing in what we have promised.
Lord, as a matter of fact, the first letter of Dr. Ambedkar, while introducing the draft constitution, makes a very interesting reading.
So his speech of 4th of December 1948.
Yes. Lord, when we go through the Constituent Assembly debates of India, Lord, we really feel as citizens that we were in safest of the hands. Lord, now this proposal contained, Lord, these principles. Principle of partition of British India was accepted by the British government. Then second, successor governments would be given dominion status. Autonomy and sovereignty to both countries, that is India and Pakistan. Then fourth and fifth is relevant. Both can make their own constitution. And fifth, princely states were given the right to join either India or Pakistan. Princely states had no option to remain independent under this plan. It comes thereafter in 1947, but Lord Mountbatten advises the Crown of the Chamber of Princes that it's not viable for most of you. You can't survive as independent units. But in this plan, they could join either Pakistan or India, depending upon several factors, but mainly the factor of geographical proximity. For example, hypothetical example, Delhi can't join Pakistan because of the land route not being available, etc. Now, my lord, next date, 27 June, your lordships may, my lord, skip, June 47. After the announcement of June 3rd plan, Lord Mountbatten spent 4 days discussing the situation of Jammu and Kashmir with the Maharaja of Jammu and Kashmir and clearly explained that independence of Jammu and Kashmir was not a feasible option. Then Viceroy, 13th of June 47, Viceroy Mountbatten invited Nehru, Sardar Patel, Acharya Kriplani, Jinnah, Liaquat Ali Khan, and Sardar Abdul Nishtar and Sardar Baldev Singh to attend an informal meeting to discuss the problem of the states. Lord, I may not read the whole. The purpose was that you create one separate department which would deal with integration of states. That was, my lord, the States Department, and the first secretary was Mr. V.P. Menon. My lord, this function under Sardar Patel. V.P. Menon was the first secretary, and he has written 2 books, my lord, as your lordships were told, on a request from Sardar Patel that you document it. You are the first person, yours have the first-hand information, and he has written both the books without being judgmental or without giving his value judgment. He has narrated the facts as he witnessed. Most of the documents are also signed by him. Letters are also signed by him. He had taken part in several negotiations also with princely states. Then, my lord, your lordships can skip 15th June 1947, Congress Working Committee. My lord, the same continued that will not accept divine rights of princely states. We are going for democracy. And, my lord, they rejected specifically the concept of paramounts. The Congress was dealing with this issue and negotiating with the Britishers and with, my lord, princely states. Then 17 June 47, Nehru wrote to Mountbatten stating that Kashmir was of first importance to India as a whole and specifically as a great strategic importance of that frontier state. We were conscious, my lord, from that day. Then, my lord, 18th June, Mountbatten urged on the Maharaja and the then Prime Minister of Jammu and Kashmir, Sri Kak, not to make any declaration of independence. He also pressed them to take measures to ascertain the will of the people and to announce their intention to send representatives to one constituent assembly or the other, that is Pakistan or India. The State Department, he told them, were prepared to give an assurance that if Kashmir joined Pakistan, this would not be regarded as unfriendly by the government of India. The Maharaja allegedly replied to the same by stating that he would never accede to Pakistan, as they were setting up a theocratic state. Mountbatten pointed out the dangerous situation in which Kashmir would find itself if it did not have the support of one of the two dominions after 15th August. Well, this is by Narayani Basu and VP Menon's book. Well, they have reproduced. Well, we have, Lord, Narayani Basu was, I think, granddaughter of VP Menon. And a very seasoned bureaucrat, subject to correction. The second part is subject to correction. Then, my lord, the State Department is formed. That date, my lord, your lordships can consider skipping. Then 3rd July 47, Sardar Patel wrote to Hari Singh stating that interest of Kashmir lie in joining the Indian Union and its Constituent Assembly without any delay, and also say that its past history and tradition demands it, and all India looks up to you and expects you to take this decision. At this juncture, India was not contiguous whole, and princely states were scattered across the length and breadth of the territory of the country. Then 5th July 47, department as the State Department was a part of the Ministry of Home Affairs headed by Sri Sardar Patel, came into being, and Sardar Patel issued a statement as under. But please see, my lord, page, my lord, is 16, your lordships can directly come to, and only the highlighted part, my lord, so that I'm not, my lord, investing your lordship's time more. I have few words to say, my lord, your lordships have. See, my lord, we have dealt with every princely state in a democratic manner, and everyone has voluntarily come, including Jammu and Kashmir, as I will show, my lord, further. I have a few words to say to the rulers of Indian states, amongst whom I am happy to count many as my personal friends. It is the lesson of history that it was owing to her political fragmented condition and our inability to make a united stand that India succumbed to successive waves of invaders. Our mutual conflicts and interrupts, quarrels and jealousies have in past been the cause of our downfall and our falling victims of foreign domination a number of times. We cannot afford to fall into those errors or traps again. We are on the threshold of independence. Then, my lord, again the highlighted part. But there can be no question that despite this separation, a fundamental homogeneous culture and sentiment reinforced by compulsive logic of mutual interest would continue to govern us. Much more would this be the case with the vast majority of states which, owing to their geographical contiguity and indissoluble ties, economic, cultural, and political, must continue to maintain relations of mutual friendship and cooperation with the rest of India. Lord, please, my lord, come to next page, my lord, 17, highlighted and bold part. But I am skipping something which is in the same breath, my lord, same line, the Lord Sardar Patel says. Nor would it be a policy, my lord, I am reading the highlighted part only, nor would it be my policy to conduct the relations of the new department with the states in any manner which severs of the domination of one over the other. If there would be any domination, it would be that of our mutual interest and welfare. Lord, this is where, my lord, Sardar Patel showed the seeds of, my lord, federalism and balance of powers. That nobody would be dominant, nobody would be subservient. The only thing dominant would be our mutual interest and unification and unity of the nation. Then, my lord, 5th July 47, the Union Powers Committee submitted its second report, my lord, which was placed by my learned senior, my lord, Mr. Sybil. Kindly, my lord, first was not placed, and I want to read fully, my lord, only a part was read, my lord, read, and it may have, my lord, potential to assist your lordships. Only a highlighted part, my lord. Or I may read, my lord, the full. Momentous changes have since occurred. Some parts of the country are seceding to form a separate state, and the plan put forward in the statement of 16th May, on the basis of which the committee was working, is in many essentials no longer operating. In particular, we are not now bound by the limitations on the scope of union powers, The first point accordingly that we considered was whether in the changed circumstances, the scope of these powers should be widened. We had no difficulty in coming to a conclusion on this point. The severe limitation on the scope of central authority in the cabinet missions plan was a compromise accepted by the assembly much, we think, against its judgment of the administrative needs of the country in order to accommodate the Muslim League. Now that partition is a settled fact, we are unanimously of the view that it would be injurious to the interest of the country to provide for a weak central authority which would be incapable of ensuring peace, of coordinating vital matters of common concern, and speaking effectively for the whole country in the international sphere. At the same time, we are quite clear in our minds that there are many matters in which authority must lie solely with the units. Stronger center, but federal structure. Therefore, we say it's more unitary than federal or more federal than unitary. That is the first rule. Units, and that to frame a constitution on the basis of a unitary state would be a retrograde step, both politically and administratively. We have accordingly come to the conclusion, a conclusion which was also reached by the Union Constitution Committee, that soundest framework for our constitution is a federation with a strong center. In the matter of distributing powers between the center and the units, we think that most satisfactory arrangement is to draw three exhaustive lists on the lines followed in the Government of India Act 1935, that is federal, provincial and concurrent. Lord, appendix to this report, Lord, please see the note. The appendix to this report had a union list with a wide array of subjects, that is 87 in total. Lord. Now we have 97. Lord. Now, Lord, kindly come to Lord, the next date, 10th July 1947. So this is a very important statement made on the floor of British Parliament by Clement Attlee, the then Prime Minister of India. This is not available otherwise, but in one of the recent judgments of the British court, where, my lord, there was a dispute regarding properties of Hyderabad's Nizam. Lord, this is quoted. He had transferred some $1 million and there was some dispute between High Commission and Nizam. That's not relevant. From there, my lord, this quotation, my lord, at the foot, my lord, I have underlined. I'll read only that part. A feature running through all our relations with the states has been that the Crown has conducted their foreign relations. They have received no international recognition independent of India as a whole. With the ending of the treaties and agreements, the states regain their independence. They had treaties with British government with regard to communication in terms of postal, railways, etc. Everything was come to an end. But they are part of geographical India, and their rulers and peoples are imbued with a patriotism no less great than that of their fellow Indians in British India. It would, I think, be unfortunate if, owing to the formal severance of their paramountcy relations with the Crown, they were to become islands cut off from the rest of India. The termination of their existing relationship with the Crown need have no such consequences. Underline, it is hope of His Majesty's government that all states will, in due course and their appropriate place within one or other of the new dominions within the British Commonwealth, but until the Constitution, etc., I can skip that. Lord, the position was clear that princely state became independent technically, but not viable independent units. Lord, may I start at
So sorry, I was with the advocates on record, they have some practical issues about filing, office, so I just, with them and it took time.
Substantive, my lord,
Our own members of the bar who have some, they are responsible to the clients. Yeah.
of course. I was on page 21. I can, my lord, again reiterate my assurance. Whatever may not be necessary for your lordship's perusal, I am skipping it. Why keeping it there, my lord? For page 21, 1947. This would be, my lord, another landmark. Therefore, I must, my lord, bring to your lordship's notice. Under section 9 of the Indian Independence Act, the Governor General of India issued India within bracket Provincial Constitution bracket over order 1947. What I have quoted is section 6. Section 5 I have not quoted. I'll just paraphrase it. It merely defined the territories and included within it the exceeding states also, exceeding states. Your lordships can, my lord, have a note.
Page.
Volume 12, my lord. Document volume 12. PDF page 103.
PDF page 21, I think.
I'm sorry, your lordships are asking about the page of the note.
Yes. Page of the note, page 20 or 28?
21.
21, I'm sorry. Page 20, my apologies. I thought your lordships are on.
Yes.
Lord, section 5, my lord, I am on 1947. That is the date, your lordship. My lord Justice
Yes,
calling, this is the vacancy. Under section 9 of the Indian Independence Act 1947, the Governor General of India.
So 1 second.
No, I'm sorry, my lord. My note. My apologies, my lord. I should have been clear. My note, which your lordships would find respondents' conjoint written submissions. Volume 3, my lord. Please, sir. But there were two sections incorporated. Section 5 I have not quoted. I just paraphrase it. It defined territories and included within the term territories exceeding states also. That's all. The lordships would like to note the page number and it's document volume 12, page 103. Now, my lord, the system of accession of Indian states. That was section 6 of this order of 1947. Please see, my lord, 1. May I, my lord? An Indian state shall be deemed to have acceded to the dominion if the Governor General has signified his acceptance of an instrument of accession executed by the ruler thereof, whereby the ruler on behalf of the state declares that he accedes to the dominion with the intent that the Governor General, the Dominion Legislature, the Federal Court and any other Dominion authority established for the purposes of Dominion shall, by virtue of his instrument of accession, but subject always to the terms thereof. Please mark this, my lord, that's the case of the other side, my lord. Therefore, I must bring it to your lordship's notice. And for the purposes only of the dominion, exercise in relation to the state such functions as may be vested in them by order under this Act, and assume the obligation of ensuring that effect is given within the state to the provisions of this Act so far as they are applicable therein by virtue of the instrument of accession. Now, two, this is important, and this was common, my lord, obviously for all who wanted to exceed or have exceeded. An instrument of accession shall specify the matters which the rulers accepts as matters with respect to which the Dominion legislature may make laws for the state, and the limitation, it should be the limitation, there is a typo, and the limitations, if any, so which the power of the Dominion legislature to make laws for the state and exercise of the executive authority of the Dominion in the state are respectively to be subject. But this is my submission and my reading, but an attempt to ensure that unification becomes as difficult as possible, because everyone were permitted to put their own terms and conditions. That if you are a princely state, you can exceed, but subject to the terms and conditions. And see how beautifully the founding fathers of our constitution, my lord, dealt with that situation, unified the nation, and the ultimate result was Article 1.
Actually, this was intended to create a sense of confidence in the princely states.
You are not losing everything.
You are acceding to the union, but we are giving you the ability to have reservations in your instrument of accession, by virtue of which you will retain certain subjects to yourself, or you will accept the jurisdiction of the federal legislature, the Dominion legislature, subject to some restrictions which you can yourself impose. So that
you have that option.
We must also put ourselves at that point of time. The Union of India wanted these princely states to come into the fold. But at the same time, we gave them that assurance that you can today decide that you will give only certain subjects to the Dominion legislature.
That can be, I think, a better way of reading it. And that's why, Sardar Patel says that the basic theme, the underlining theme would be mutual interest and welfare.
Just as an aside, these instruments of accession, the draft, was there a model draft?
Yes, that is coming.
That was prepared by the Department of States, or who prepared that draft?
That is next day. Right. That is next day. And that was common for all. Not I'm sorry, the subsection 3, learned AG is guiding me to
the variation of the instrument by a supplementary.
By a supplementary instrument executed by him and accepted by the governor, vary the instrument of accession of his state by extending the functions which, by virtue of that instrument, are exercisable by any dominion. So he can forego, he can kind of waive, or he can permit the dominion to do that. Then Lord Mountbatten, speaking to the Chamber of Princes as Crown Representative on 25th July, negotiating committee constituted of 10 rulers and 12 ministers of princely states. This apparatus had in fact been decided upon after heated political debate. Full statement at so and so. I am not reading it, but note, in this process, a model draft of instrument of accession was made. This draft is signed by all princely states of Jammu, and Jammu and Kashmir has not signed any instrument of accession, either special or having any different version at this stage. Now, my lord, India attained independence. So your lordship would like to see the draft, my lord? That would be...
No, that's okay. That's all right. It's not. We need not break the flow.
Page 23. After 15th August 1947, after independence, Lord Ismay, on the recommendation of Lord Mountbatten, went to Maharaja of Kashmir to persuade him to choose one of the dominions. Then 27th September 47, Nehru wrote to Sardar Patel claiming that the Pakistani strategy is to infiltrate Kashmir now and to take some big action as soon as Kashmir is more or less isolated because of coming winter.
Nehru had anticipated.
And these words proved to be prophetic. This, in fact, happened, and as it is pointed out subsequently. Then Pakistan continued hit and run border raids in Kashmir, Then 2nd October 47, Sardar Patel writes to Hari Singh, stating that Sheikh Abdullah will be coming to Delhi shortly and we shall endeavor to reach a sensible solution to the difficulties you have from that quarter. So that is, the quarter means the Sheikh, that you have some problem which are flagged by Sheikh Abdullah ji, so we will sort it out. Then your lordships would find 15/10/1947, Meherchand Mahajan, Lord, he was the Prime Minister of the then Kashmir, and Lord, incidentally, Lord, he became Lord, a judge of federal court and Lord, eventually Lord, sat in this court Lord, as a Chief Justice of India. Complained to the British Prime Minister that government of Pakistan had broken the standstill agreement, which was between Kashmir and Pakistan. And the whole of state border from Gurdaspur to Gilgit was threatened with invasion, which had already begun in Punch. Then government of Jammu and Kashmir sent a protest letter to the Governor General and the Prime Minister of Pakistan against breaches of the standstill agreement and the continuous raids. Then, my lord, your lordships can skip this. In the autobiography of Justice Mahajan, Lord, this incident is narrated that when he was traveling along with the Maharaja of Kashmir, how his life and the life of the king was saved, my lord, by a sheer coincidence of an intuition of the king that instead of this guest house, we may better stay in some other guest house. So that's all, my lord. Then your lordships may kindly see 22nd October 1947. All-out invasion of Jammu and Kashmir started, consisting allegedly of local tribesmen. The other side also, my lord, repeatedly said that there were tribe leaders who were conducting raids. I'll point out the contemporaneous letter written by the king to the government of India. And my lord, Sri V.P. Menon. The raiders destroyed the Uri Bridge and captured Mahura powerhouse, which supplied electricity to Srinagar, which plunged Srinagar into darkness. It was announced that they would reach Srinagar within 2 days. Then 24th October 47, Government of India received a request for help from Maharaja. Then 25th of October 47, the meeting of Defence Committee was held, presided over by Lord Mountbatten, wherein it was decided that the Home Secretary V.P. Menon should fly to Srinagar immediately to study the situation on ground and report the same to the Government of India. V.P. Menon landed in Srinagar and found the entire city, into inverted comma, I quote, oppressed by the stillness as the graveyard all around, unquote. Sri Menon met the PM of Jammu and Kashmir, Sri Meherchand Mahajan, who appraised Sri Menon to the perilous situation and pleaded the Government of India to come to the rescue of the state. Then 26th October 47, the next morning Sri Mahajan called Sri Menon that there were rumors that raiders had reached Srinagar. Sri Menon and Sri Mahajan flew back to Delhi. Sri Menon went straight to the meeting of the Defence Committee and reported the impressions of the situation and pointed out the supreme necessity of saving Jammu and Kashmir. It was pointed out by Lord Mountbatten that till the time Jammu and Kashmir does not accede to India, it would be improper to move Indian troops, and accession would be the only basis which would rightfully give the right to Indian forces to retaliate against the invasion of Kashmir. After the meeting of the Defence Committee, Sri Menon and Sri Mahajan flew to Jammu and woke up the Maharaja and informed him of the developments that had taken place in the Defence Committee meeting. Maharaja desired to accede, reiterated his request for military help, and further informed his intention to set up an interim responsible government. Then your lordships may kindly come to this letter sent by, contemporaneous letter sent by the king, Lord, to Sri Menon, that is volume 1, document volume 1, page 7. This would be, my lord, relevant for your lordship's assistance. What way, my lord, I'm sorry. Document volume 1, PDF 7.
We've actually read this letter where the Maharaja says that, he had not decided whether to be independent or join the
That
Dominion.
was the only part which was read, my lord. I would like your lordships to read, my lord, at page 8, 2 paragraphs, my lord, which were, my lord, not.
Yeah, he refers to the mass infiltration and other things.
So kindly see the first. The mass infiltration tribesmen drawn from the distant areas of northwest frontier coming regularly in motor trucks using Manshera-Muzaffarabad road and fully armed with up-to-date weapons cannot possibly be done without the knowing of the provincial government of Northwest Frontier Province and the government of Pakistan. In spite of repeated requests made by my government, no attempts have been made to check these raiders or stop them from coming to my state. The Pakistan radio even put out a story that a provisional government has been set up in Kashmir. The people of my state, both the Muslims generally, have taken no part at all. With the conditions obtaining at present in my state and to great emergency of the situation as it exists, I have no option but to ask for help from the Indian Dominion. Naturally, they cannot send the help asked for by me without my state acceding to the Dominion of India. I have accordingly decided to do so, and I attach the instrument of accession for acceptance by your government. The other alternative is to leave my state and my people to freebooters. On this basis, no civilized government can exist or be maintained. The alternative I will never allow to happen as long as I am the ruler of the state and I have life to defend my country.
So this letter is taken by Mr. Menon to Sardar Patel, and the Maharaja said that he had instructed his ADC that if Menon comes back, well and good. That means, everything is according to plan. Otherwise, he said, shoot me when he told his ADC to shoot him dead when he's asleep, he said. He said, if he comes back, don't wake him up. He said.
Don't wake me up. Otherwise, if he doesn't, then shoot me, because I would not like to be shot by the enemy forces. That was that's how, my lord, beautifully sent later, my lord. So long as there is a life in me, I'll defend my people. Now, my lord, I am coming back to page 26, my lord.
Yes, now.
The second, my lord, this is accepted. The instrument of accession is accepted. Then 27th October 1947. Your lordships have page 27.
Yes.
Second date, 27 October 47, a Herculean airlift operation of Indian troops was carried out in order to carry out the rescue operations in Jammu and Kashmir, which we continued till 2019. Now it has stopped. Possibly the only provision which is not only mentioned to be temporary, but has been understood by all subsequent parliament to be temporary, has managed to continue for 75 years. The moment Jinnah heard that India has accepted Jammu and Kashmir accession and Indian troops had been airdropped into Kashmir, he gave orders to General Gracie, acting Commander-in-Chief in Pakistan Army. General Gracie represented his inability to issue any instruction without approval of the Supreme Commander. Field Marshal so-and-so informed Jinnah that considering the fact that Jammu and Kashmir had signed an instrument of accession, it would not be possible for British officers serving in Pakistani army to enter Jammu and Kashmir. Thereafter, Jinnah invited Nehru to Lahore to discuss the Kashmir problem. Lord, now how, Lord, this is averted. Lord, the diplomacy at its best. Mountbatten was eager to accept the invitation and Nehru was inclined to agree with Mountbatten. However, Sardar Patel was strongly opposed to the proposition on the ground that Pakistan was the aggressor in this case and India ought not to follow the policy of appeasing the aggressor. As there was a difference of opinion between Nehru and Patel, the matter was referred to Gandhiji. Gandhiji called Nehru, Sardar Patel and Sri Menon to Birla House. During the discussion, it was found that Nehru was running a high fever and his going to Lahore was out of question. It was decided that Lord Mountbatten should go alone. V.P. Menon writes this without any value judgment, without giving his personal views or comments, as a fact as it happened.
Sometimes running high fever is also an act of diplomacy.
Yes, sir, it is, and it was in this case. Yes. It was a diplomatic illness and it was required in the interest of the country. Absolutely right. That you should not go. That they are aggressors and we shouldn't be appeasing.
Sorry?
Which we normally send to the courts.
It was a
Something like that.
not 5 days. That's what my learned friend is trying to.
He was ready to go to Pakistan. The cabinet put its foot down that it can't be that they are aggressor and our prime minister goes crawling to Lahore to meet Jinnah.
So now please see, 16/12/1947, Sardar Patel, I am at page 27, last date on that page. Sardar Patel issued a statement. Public has already received through the press and over the radio a fairly clear and detailed picture of the settlement. Your Lordships can come to only
the highlighted portion actually.
Underlined portion. Democratization of the administration, which has long been the keynote of Congress policy towards the state, has become a pressing problem since August 15. The princes themselves have in many cases begun to realize the spirit of times and have been gradually introducing measures in accord with that spirit. The progress has been in some states low, in other it has been swift, but everywhere it has been sure. Your Lordships can thereafter skip the rest. Then last lines on this, provincial administration in this process of unification and amelioration so that they may derive the full benefit of this great achievement. Then, white paper, I have just given the summary. Before the Constitution of India came into force, a Herculean task of unionization and democratization, ensuring local popular government in place of hereditary princes was going on. For the said process, instrument of accession and standstill agreements were signed. Thereafter, the policy was followed which involved merging the smaller states that were not seen by the government of India to be viable administrative units either into neighboring provinces or with other princely states to create a princely union. It was felt that smaller states lacked resources to sustain their economies and support their growing populations, impose tax rules and other restrictions impeding free trade, and without integration, the economies of the states would collapse and anarchy would arise if the princes were unable to provide democracy and govern properly. Note, this was done despite the instrument of accession and despite assurances given by the State Department and Lord Mountbatten during the accession process. There were promises held out, as in one of the judgments referred to, but that judgment is thereafter reconsidered. I'll come to that. That these promises after the Constitution of India comes into force have no meaning. It is the Constitution which is supreme and the only sovereign is we the people of India. There is a judgment on that. In December 47, princes from the East India Agency and Chhattisgarh Agency were summoned to an all-night meeting with Menon, where they were persuaded to sign merger agreements integrating their states into Odisha, the central provinces and Bihar. Thereafter, 66 states in Gujarat and Deccan were merged into Bombay, including large states of Kolhapur and Baroda. Other small states were merged into Madras, East Punjab, West Bengal, and United Provinces and Assam. 30 states of former Punjab Hill States Agency, which lay near the international border. Similarly, this continued to happen depending upon the geographical situation, but But I'm not reading the examples, but there is one example, my lord, which is very, very striking example. But there were many of this kind. But out of 506 plus princely states, about 200 plus were only in one region of Gujarat, that is Saurashtra region. They formed United States of Kathiawar. There was a separate country which functioned for some time and thereafter merged. But they signed a treaty of accession. Kindly have a look at the treaty of accession, page 30. The revised treaty of accession, revised instrument of accession. The purpose of my showing is this. Like Jammu and Kashmir, every princely state had put their own conditions. But eventually, my lord, the theory of Act of State and Article 363, that all treaties, etc., get subsumed in one document, namely the Constitution of India. Please see, my lord, page 30, the highlighted part, that all subjects except matters relating to taxation. That those princely states said that taxation will be our subject. You will not touch. The Union of India, the Dominion of India will not touch taxation. Please come to, my lord, page 31. After 3, the proviso. Does my lord get? Page 31, it is a part of this revised instrument of accession. Clause 3, proviso. My lord, Justice Surya.
Yes.
Provided that nothing contained in the said list or in any other provision of the Act shall be deemed to empower the Dominion legislature to impose any tax or duty in the territories of the United States. United States means United States of Saurashtra. Or to prohibit the imposition of any duty or tax by the legislature of the United States in the said territories. Please come to, my lord, page 32. There are 2 clauses. This is to show every state had put their conditions. 7. Clause 7. This is again part of, my lord, the revised instrument of accession. Nothing in this instrument shall empower the Dominion legislature to make any law for the United States authorizing the compulsory acquisition of land for any purpose but subject the Dominion for the purpose of a Dominion law which applies in the United States deem it necessary to acquire any land. The Raj Pramukh of the United States shall, at the request and at the expense of Dominion government, acquire the land, or if the land belongs to the United States, transfer it to them on such terms as may be agreed or in default of agreement determined by an arbitrator so and so, so and so. Well, till the princely state remained, even after independence, they were called Raj Pramukhs. Even after the federal units, namely the states.
Until the 1956, 1956 amendment.
56.
When the Raj Pramukhs were abolished and you had the governor.
The governors, not the princely state. But 8. Nothing in this instrument shall be deemed to commit the United States in any way to acceptance of any future constitution of India. This is not, my lord, in Jammu and Kashmir. It is reverse, I'll show. But they say, I am not admitting that I'll accept the future constitution of India in any way to acceptance of India or to fetter the discretion of the government of United States to enter into agreements with the government of India under any such future constitution.
The only difference was that this constitutional history led to the ultimate integration in every sense of the other states like Kathiawar, Saurashtra, Baroda. They didn't follow the 370 route because for J&K, the constitution decided to go to 370. The other states, there was no provision like 370. They merged and they were integrated completely. They accepted list 1, they accepted list 3. They accepted the ultimate dominion powers, executive and legislature of the Dominion of India.
I am just showing this with a view to make one point, that a stand which is now being taken and which has been taken, that we had a special feature and therefore we were given a special treatment, and therefore this provision is kind of a privilege given to us which can never be taken away. But I'm just trying to show that there were many similarly situated princely states They had also put their conditions, but eventually they subsumed themselves with the Union of India because of the Act of State doctrine and because of Article 363 and Article 1. But
they came into the Indian Union as a volition. They joined voluntarily. I mean, we take it as voluntarily. It may have been a little bit of persuasion. It may have been whatever. Real politics. Yes, obviously. Obviously, no difficulty. And that was probably the genius of Sardar Patel. There's no difficulty. There's no doubt about it. But the fact, however, remains that insofar as J&K is concerned, J&K bucked that trend. J&K went to the 370 route.
Yes, my lord, but why, how, and till what time?
Right.
That will come, my lord, subsequent.
Right.
And that's why, my lord, for me, as I said, my lord, in the outset, connecting the dots would be necessary.
So the limited point which you are making at this stage is that the instruments of accession of various princely states contain certain reservations. Now we have seen in regard to taxation, in regard to land acquisition,
binding constitution.
Not binding themselves to accepting a future constitution. So the IOAs at that point of these states were hedged with various conditions.
This is also.
But that was consistent with Section 6 of the Government of India Act, which was adopted by Section 9 of the Indian Independence Act. We gave this sop to the princely rulers that, look, you come here on your terms. We are not telling you today to come on our terms. You agree to the Indian Union, you make reservations, and we hope that by and by you will accept full integration into the Union, which they did.
Another point why I wish your lordships made aware of this development is, there was an argument that instrument of merger was a necessary attribute for a complete integration. Otherwise, we had kind of an internal sovereignty. Your lordships would recall that Jammu and Kashmir never signed instrument of merger. Many states did not sign instrument of merger. From the date on which Constitution of India came into force and Article 1 came into force as an act of the state, they became integral part of Union of India. And how Jammu and Kashmir got separated, my lord, and how it was only for a temporary period, but would succinctly come, my lord, in subsequent.
Interesting, Mr. Solicitor, this Department of States which existed in the Ministry of Home Affairs post 1950, after the 7th Amendment, right? 1956.
238 was, yes.
So the Department of States must have been abolished post 1956. You will be still having records in the Ministry of Home Affairs?
I'm sorry, my lord, my instructions are, officer sitting, my lord, was the additional secretary in charge of Jammu Kashmir in MHA. He said that department technically still continues.
So Department of State still continues.
Still continues.
Now, do we have, I'm not sure whether this exercise can be done just for, I mean, you don't have to do it by a very detailed document, but just a tabulation. If we can have a list of the states and, you know, we can have, say, Kathiawar, instrument of accession, supplementary instrument of accession, and merger agreement. Which of the states came into the union with a merger agreement? Which of the states had no merger agreement at all and yet joined the union? I don't know whether that now at this point of time that record will be there. If you can try and record, if you can sort of.
Yes. To a large extent, white paper indicates what happened.
I don't know if you have that record. I mean, how many out of these 562 who actually joined the the Union of India, actually executed merger agreements?
What happened?
What I meant was, how many of these states which joined the Union of India did not execute merger agreements? That will be a smaller group probably.
But possibly.
So, which will then perhaps give some support to your argument that the execution of a merger agreement was not quintessential to acceptance of ultimate sovereignty by India. And second, many states, many princely states, were subsumed with the Union of India even without a merger agreement. And various states, therefore, were subsumed in the Union of India only with an instrument of accession.
We'll do that exercise. Substantially, everything is there in the white paper. But if there is nothing else also, Manoj,
all 562 states, not India, what happened was there were small little principalities, small nawabs. They got into larger.
We were just, in fact, Brother Suryakant was giving us a little bit of backdrop about Punjab and Himachal.
To integration with larger states, and then the larger one finally signed the instrument of merger.
Right, but we were wondering, was it possible? Because Mr. Sibal, what we want a little bit of just factual.
I've understood, madam.
Factual clarity, that they may have, were there Indian states, we shouldn't call them princely states, because as Mr. Sibal says, some of the small Nawab, some the princes.
We will have to say princely states, because Indian state would mean those which were
Governors'
under the
provinces.
sovereignty or suzerainty of
British
India. That's how it has
They were the
always been
governors'
like.
provinces.
That's right.
No, but we just want to know this,
We will, my lord, undertake.
again, to sort of repeat two things. Which were the states which accepted completely to be subsumed within the Union of India without merger agreements, and followed only the IOA course and straight came into the Union of India?
No such instance, but with respect. The white paper which is part of the record. White paper issued by Sardar Patel.
I will not formulate it. I have understood the question. Let me not.
You know, Mr. Shankana, I just thought since the Department of States exists even today, this is something, this will be, they might take a day or 2 days, but they will be able to do it.
It would be, Malad, it would be done.
The table here, but the states which have not entered into a merger, helping your point. Actually, if you want a list of states which have
What
not.
is the source? What is the source of your table?
It's from the white paper.
White paper, there are inaccuracies, I'll put it that way.
So there are states which did not accept the merger and yet became a part of the Indian Union.
State of Mysore, state of Saurashtra pre-independence, Madhya Bharat, Patiala and East Punjab.
This is.
And this is part from the white paper, there is a chart.
We will, Malad, let's not, Malad, deviate from it. I have, Malad, taken the point.
Your point is that there were other states, basically whether it was 2, 3, 4, 5, whatever, there were other states which did not sign the merger agreement.
Yes, there was nothing special which is being claimed.
That's your point. I'm just
And second, that merger was such a sine qua non, without which you can never be an integral part of India, either under Article 1 or otherwise, or your special status must continue. But please do not.
So in other words, Mr. Solicitor, to sort of paraphrase your submission, it's twofold. First, the expression of reservations in the instrument of accession was not unique to the instrument of accession which was executed by Maharaja Hari Singh.
I couldn't put it that way.
To the execution of a merger agreement was not a sine qua non to be absorbed or become a part of the Indian Union. It's a twofold. We got the point.
So please come to para 30, to page 32 bottom, my notes. Note 1. The assertion of the petitioners that all others signed the instrument of merger except state of Jammu and Kashmir is false. Several states signed revised instruments of accession, including therein different conditions, etc. I have seen. Neither this process of integration, unionization, linear in its legal application, nor assurances or negotiations remained sacrosanct while framing the Constitution of India and making of this great nation as Union of India. There were states which did not sign revised instrument of accession or merger agreement also joined as part of Union of India. The same thing my lords were indicating. As and when such inclusion of the state took their respect, representative kept on being included in the Constituent Assembly and Schedule 1 kept on being amended, adding each state. Once the Constitution of India came into being on 26 January 50, all states mentioned in Schedule 1 being part of Union of India, losing their sovereignty, if any, which was an act of state, and this is how countries are formed. With coming into force of the Constitution of India, only the Constitution remained the supreme document vesting sovereignty in the people of India, and all other documents got subsumed in one sacred document, that is the Constitution of India. Thereafter, no princely state has successfully asserted its claim based upon any previous document, be it instrument of accession, revised instrument of accession, or merger agreements. The princely states also retain their right to not commit to the future constitution. However, the application of Indian constitution through Article 1 was not dependent upon the same. Two, my lord, your lordships can skip. Kindly come to, my lord, page 34. My learnation want me to read. The instrument of accession had its source in section 5 and 6 of the Government of India Act. I'm sorry, my lord, my learnation is right. I should have. There is no statutory source of merger agreements, and they were only signed in some cases as a result of negotiations between some states and Dominion of India. It seems, but it's more because of binding the princely state not to go back from its word that they were signed. It doesn't have any statutory source like instrument of accession. Then note 34. 4/11/48, the draft constitution was introduced in the Constituent Assembly. Upon its introduction, Dr. Ambedkar gave a speech outlining how, my Lord Justice Gawai was referring to this, outlining how the constitution was meant to function and how governance under the constitution was to be conducted. Notably, Dr. Ambedkar made clear, Lord, please come to Lord volume CCD 8, I'll read only 2 paragraphs, not the entire speech, because a part was read, part which was not read, my lord, I would wish, my lord, your lordship, attention is invited, was CCD volume 8, PDF page 63 at 75.
Documents volume
8.
Lord, document volume 8, PDF page at 75. 64 at 70. Starts at 64 at 75. Only one paragraph, which was not read, therefore I am reading it. Because according to me, this is the heart of what Dr. Ambedkar felt.
single P.
2936.
2936, yes, my lord, running page 2936. Lord, unnumbered second para, some critics, your lordships have. Some critics have taken objection to the description of India in Article 1 of the draft constitution as a union of states. It is said that the correct phraseology should be a federation of states. It is true that South Africa, which is a unitary state, is described as a union, but Canada, which is a federation, is also called a union. Thus, the description of India as union, though its constitution is federal, does no violence to usage. But what is important is that the use of the word union is deliberate. I do not know why the word union was used in the Canadian Constitution, but I can tell you why the drafting committee has used it. The drafting committee wanted to make it clear that though India was a federation, federation was not the result of an agreement by the states to join in a federation, and that the federation not being the result of an agreement, no state has the right to secede from it. The federation is a union because it is indestructible. Though the country and the people may be divided into different states for convenience of administration, the country is one integral whole. Its people a single people living under a single imperium derived from a single source. This is the heart and soul of Article 2.
There is also a reference in his speech of 25th of November 1949.
When? Yes, for last closing.
Last speech. He says that our Constitution is unique. It is federal at the same time unitary.
It is, my lord, it will come, my lord, in the chronology.
This speech of Dr. Ambedkar also lays bare the distinction between a constituent assembly and parliament. At bottom of that page.
Yes, but that was read by Mr. Sibal, therefore I missed it. But I can go to that.
No, that's right.
But Lord, this was not read. So I'm not repeating what was read. Lord.
Absolutely.
Yes,
absolutely.
Then your lordships may not come to the date 16th June 1949. Sheikh Abdullah joins the Constituent Assembly alongside three other representatives from the state of Kashmir, namely Mirza Muhammad Afzal Beg, Maulana Muhammad Saeed Masoodi, and Motiram Bagda. Now, my lords may kindly see the territorial integration. Lord, this is a part of the white paper. Mr. Sibbal, my lord, read up to a particular point. I would like your lordships to read further. Therefore, I have quoted in full. Territorial integration. One of the important consequences of the adoption of the new constitution. Does your lordships get, my lord?
Yes, sir.
35, my lord. I am reading. One of the important consequences of the adoption of the new constitution is completion of the process of territorial integration of the states. The states geographically contiguous to the dominion of India as they existed before the Constitution of India became operative could be divided into two main categories. One, the exceeding states, and two, the non-exceeding states. There were only two non-exceeding states, namely Hyderabad and Junagadh. The exceeding states could be subdivided into the following groups. A, states which were not affected by the process of integration and continued as separate units, i.e. Mysore and Jammu and Kashmir. This was read by the learned counsel. B, union of states. C, centrally merged states. D, provincially merged states. And E, Khasi Real Estate Federation. Please read, my lord, further. This, my lord, I think required to be read. Under the new constitution, all the constituent units, this is new constitution, Article 1, Schedule 1. Under the new constitution, all constituent units, both provinces and states, the later term includes non-exceeding states, have to be classified into three classes. That is Part A states, which correspond to the former governance provinces, directly under sovereignty or suzerainty. Part B state, which comprises the unions of states and the states of Hyderabad, Mysore and Jammu and Kashmir. And Part C states, which correspond to the former chief commissioners provinces, which became UT thereafter. The new constitution effects the territorial integration of states by means of twofold process. Firstly, Article 1 of the Constitution defines the territories of India to include the territories of all the states specified in the first schedule, including Part B states. This is an important departure from the scheme embodied in the Act of 1935, in that while Section 311(1) of that Act defined India to include British India together with all territories of Indian rulers, the Act did not define territories of Indian Federation. Secondly, with the, please note this, my lord, secondly, with the inauguration of the new constitution, the merged states have lost all vestige of existence as separate entities. That is, my lord, first schedule to the constitution. My lord, thereafter, your lordships can, my lord, skip. Your lordships may come to, my lord, 8.849. This is how, my lord, you retain your sovereignty. I have given an example that internal and external sovereignty, my lord. For example, we have a treaty. I'm sorry, my lord. I'm sorry. I missed one. July 49, my lord. Kindly see, my lord, July 49. Note by the Ministry of States regarding the Indian states, it was specifically noted that Jammu and Kashmir would be treated as a part of Indian territory. Please read only first para. This note was before the Constituent Assembly. We have checked it. The government of India have considered the matter in its various aspects and are of the opinion that in view of the present peculiar situation in respect of Jammu and Kashmir state, it is desirable that the accession of the state should be continued on the existing basis till the state could be brought to the level of other states. Idea was prevailing situation then, not instrument of accession or lack of merger, etc. The prevailing situation then. Idea was to bring it at par with other states. And the important part, a special provision has therefore to be made in respect of this state on the basis suggested above as a transitional agreement. arrangement. This was the promise, my lord, by the Constitution Assembly to the nation, that as a transitional arrangement, we are making a provision, a departure from other states. Lord, second, my lord, 8849, your lordships can skip.
No, Mr. Solicitor,
Yes, sir.
you may read little below that also.
Yes.
The Ministry of State
The
suggests.
Ministry of State suggests
Oh, that's
for
very
consideration of the drafting committee the following approach to this question. One, Jammu and Kashmir state may be treated as part of Indian territory and shown in states specified in part 3 of Schedule 1. I'm obliged, Lord, I'm going a little faster.
Go further on.
Yes. A special provision may be made in the Constitution to the effect that until Parliament provides by law that all provisions of the Constitution applicable to the states specified in Part 3 will apply to this state, the power of Parliament to make laws for the state will be limited to the items specified in the schedule to the instrument of accession till Parliament makes the law governing the accession of the state to the dominion of India or to corresponding entries in list 1. Lord, this is very important. I missed it, Lord. I am really grateful, Lord. Then, Lord, 8849 is just an example how to retain your sovereignty. That is, my Lord, Bhutan. Bhutan has a treaty with us. Contemporaneously signed, my Lord, in 4750, my Lord, that is 8849, where, my Lord, in external affairs, India has suzerainty. We don't have sovereignty. They are sovereign, but, my Lord, we have the 12-10-49. In a speech to the Constituent Assembly, Sardar Patel stated that although the initial policy of the government was to permit states to have a separate constitutions, this idea had now been dropped as a legacy from the rulers and the polity, and that in a people's polity, there was no scope for variegated constitutional patterns. We therefore discussed this matter with the premiers of various unions. Unions means the princely states or association kind of a thing, and decided with their concurrence that the constitution of the state should also form an integral part of the Constitution of India. The natural implication of this statement is twofold: that Article 370 was of a temporary nature, and that it was meant to last only until the disturbed situation in Jammu and Kashmir was normalized. Now, Lord, is interesting. Draft Article 306, Gopala Swami Iyengar had discussed the position of draft Article 370 in detail with Pandit Nehru before his departure to United States. Lord, generally speaking, when we go through, Lord, Gopala Swami takes the line which Pandit Nehru wants him to take. Lord, and there is some difference of views between Sardar Patel and Nehru on this issue. Principled differences. However, there was strong opposition in the Indian National Congress for giving any special provision. The same has been noted as under in my reminiscences of Sardar Patel by Vishnu Shankar. Lord, Vishnu Shankar was the principal secretary to Sardar. He was secretary within Becket Kashmir in those days and rose to become the cabinet secretary. Lord, his version is considered to be one of the authentic versions of what transpired during that period. Please read, my Lord, what he says. In the party, there was a strong body of opinion which looked askance at any suggestion of discrimination between Jammu and Kashmir state and other states as members of the future Indian Union, and was not prepared to go beyond certain limits in providing for the special position of Jammu and Kashmir. Sardar was himself fully in accord with this opinion, but due to his usual policy of not standing in the way of Pandit Nehru and Gopala Swami Iyengar, who sorted out problems in their own light, he had kept his own views in the background. In fact, he had not taken any part in framing the draft proposals, with the result that he heard the proposals only when Gopala Swami Iyengar announced them in to the Congress party. The announcement was followed by a storm of angry protest from all sides, and Gopalaswamy Iyengar found himself a lone defender with Maulana Abul Kalam Azad, an ineffective supporter. Metaphorically, the situation may be succinctly described by saying that both Gopalaswamy Iyengar and his proposal were torn to pieces by the party. Now, J&K was included in Part 3 states under Article 1, and its territories were defined as the territory which comprised of the corresponding Indian state immediately before the commencement of the Constitution. Then, my lord, I have given the list, your lordships can skip. Please come to 151049. 4 seats were allocated in the Constituent Assembly to Kashmir. The debate is quoted as under. My lord, please come to page 39, somewhere in the after the figures. The foregoing paragraphs have dealt with changes in the numerical strength of the Constituent Assembly and in its representative character. That was, however, a series of changes of a different kind in the representation accorded to the Indian states, which deserve separate mention. While the Constituent Assembly was in session holding its deliberations between December 46 and November 49, many of the smaller states were merged in provinces. Many others were united to form United Union of States, and some were directly administered by the center as chief commissioners provinces. These changes necessarily called for a readjustment of representation of states from time to time. The general plan adopted was as follows. The states were merged in provinces. The Speaker of the Legislative Assembly of the province was authorized to hold elections and by-elections wherever necessary and notify the person or persons elected or nominated. 2. Where the states were united to form United Union of States like United States of Kathiawar, and in case of Hyderabad, Mysore and Jammu and Kashmir, the Raj Pramukh or the ruler of the state was entrusted with this function of selecting, not obviously not electing. And 3, in case of states constituted into chief commissioners provinces, this function was entrusted to the chief commissioners. So far as allocation is concerned. Now kindly come to the next. But this is a very, very important letter, my lord, in my respectful submission and from my perspective. 1610-1949. On the evening of introduction of draft Article 306A, that is erstwhile 370, after Gopalaswamy Iyengar shared the draft of the article, Sardar Patel wrote a scathing letter to him, making his position clear as under. My dear Gopalaswamy, thank you for your letter dated so-and-so, which I received only this afternoon on my return from Constituent Assembly. I find there are some substantial changes over the original draft, particularly in regard to applicability of fundamental rights and directive principles of state policy. You can yourself realize the anomaly of the state becoming a part of India and at the same time you can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. And I'll show till 76, Article 21 was not applicable in a truncated way. Article 19, there was a sub-article added as it applied to Jammu and Kashmir, that the reasonable restrictions would be those which will be prescribed by the legislature, meaning thereby the persons against whom citizens invoke Article 19 would decide what would be the reasonable restrictions. I'll come to that. I do not at all like any change after our party has approved of the whole arrangement in presence of Sheikh Sahib himself. Whenever Sheikh Sahib wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government, or even on a personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is the right thing to do, you can go ahead. Clear. No ambiguity. No. Then, my lord, next date. Then, my lord, Jammu and Kashmir was, my lord, received 4 representatives. Then, my lord, 7. I am on page 14. Yes, 17/10/1949. Draft Article 306A, which is the present Article 370, was debated in the Constituent Assembly. Gopalaswamy Iyengar, who was chiefly involved in the drafting of Article 370, gave a speech in which he stated that regard to the accession of the state, that, kindly see, my lord, only the highlighted part, as the House is also aware, not at page 42, as the House is also aware, instrument of accession will be a thing of the past in the new constitution. The states have been integrated with the Federal Republic in such a manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the Republic. Please mark this one. But they are mentioned in the Constitution itself, and in case of practically all states other than the state of Jammu and Kashmir, their constitutions also have been embodied in the Constitution for the whole of India. All those other states have agreed to integrate themselves in that way and accept the Constitution provided. Maulana Hasrat Mohani, why this discrimination, please? But just pausing here for a minute so that the debate doesn't get boring. Maulana Hasrat Mohani was an eminent Urdu lyricist of his time. And if all of us, most of us have heard, Chupke Chupke Raat Din Aansu Bahana Yaad Hai. That is by Maulana Hasrat Mohani. I don't want to sing it. I know my limitations, and I'll spare all of you on the lightest. Then, my lord, but there are several good lyrics, good Urdu ghazals and nazams written by Maulana Hasrat Mohani. Yes, yes. The question is very important. Why are you discriminating from people of one state and people of other? And your lordships would be shocked when I show the discrimination. We have analyzed, my lord, how the provisions were selectively picked up, modified and applied to one state. And I am not saying that my power is taken away or state's power is taken away. So far, the residents of Jammu and Kashmir were being deprived of what I will show to your lordship. Till 5th of August 2009. The Honorable Sri N. Gopalaswamy Iyengar, he replies, the discrimination is due to special conditions of Kashmir. That particular state is not yet ripe for this kind of integration. It is the hope of everyone here that in due course, even Jammu and Kashmir will become ripe for the same sort of integration as has taken place in case of other states. Cheers. At present, it is not possible to achieve that integration. There are various reasons why this is not possible now. I shall refer again to this later. Please note this, my lord. Then after acceptance of 370, V. Shankar expressed his disappointment at the passing of the special provision. Sardar Patel summoned him to lunch. The description of the said meeting in my Reminiscences of Sardar by Vishnu Shankar is as under. His principal secretary, who was Secretary Jammu and Kashmir and became the Cabinet Secretary. Please note, my lord, read one by one, my lord, beautiful words. As soon as I was seated, Sardar spoke. So you are annoyed with me for having accepted Gopalaswamy's formula. I queried that if he felt that way, why did he not indicate his mind earlier? He said, see the maturity of the man and the statesmanship. I was deeply concerned at the situation. Gopalaswamy had acted under Panditji's advice. If Jawaharlal were here, we could have had it out of him. But how could I do so with Gopalaswamy, who was only acting under orders? If I did, people would have said that I was taking revenge on his confidence when he was away. Gopalaswamy had appealed to me for help. How could I have let him down in absence of his chief? Since my Prime Minister is not present, I'll not let him down since my Prime Minister is out of the country. I then asked why he had let down the country and other states whose constituent assemblies had been scrapped in accordance with his advice and policy. He conceded the validity of the criticism but pointed out the delicate international position of the state and the issue of its relationship with India. We felt that the present situation had to be tied over without giving up the eventuality, and this had been done under the formula. Please note this, my lord, this only Sardar could have spoken, and now, my lord, it has proved to be, my lord, prophetic. He said that after all, neither Sheikh Abdullah nor Gopalaswamy was permanent. The future would depend on the strength and guts of the Indian government.
This is not a political.
And if we cannot have confidence in our strength, we do not deserve to exist as a nation.
If I may just seek the permission of the learned solicitor general. We were all told on 3rd of July to file all documents.
Again,
nothing to file there.
Continues.
This is Mr.
Sri Singh,
You were given, all of you were given.
Mr. Singh, let him continue. I mean, what's
this side patient.
Uncomfortable.
When your side argued, there was no interruption from either the attorney or the solicitor.
Lord, many of them provided additional documents, additional judgments. We never objected.
These are well established. These are well known.
Why such sensitivity
books
over some
and
statement which comes because may not be palatable.
Also, Mr. Singh, equally we know that when we decide the matter, we have to give primary importance to primary sources,
Yes.
such as the statutes, the instruments of accession. These are other documents which he is relying on. The extent to
Nurani was not even born when all this happened.
It's extract put in a list of dates.
I did object to Nurani. It's a one-sided
No,
picture.
your nodal counsel argued that he received it Sunday evening.
I'm sorry.
Your nodal counsel, he agreed in the morning that he received it long back, but he did not circulate it amongst you.
On Sunday, last Sunday.
I'm saying that there are extracts from a book in a list of dates. The book is not on record. It's not a document before your lordship.
We'll give you copies of the book.
That's not the point. I mean, this can just keep getting enlarged. I'm only saying that let's stick to the record. We were
Lord, if
told-
AG Nurani can be read, even a newspaper can be read. I'm sorry, I'm saying this with seriousness. I have read AG Nurani. It is a one-sided. But we didn't object.
That's all right. The solicitor, you don't have to go that far.
No, my lord, I'm on page 40.
Mr. Singh, all that this really indicates, it's not like, conclusive evidentiary material.
Yes.
This is used to demonstrate that there were different points of view, different perspectives which were flowing in at that time.
A historical perspective of what people felt at that particular time.
There are several
And
things
in
mentioned
internal
by
dialogue that was
I would-
taking place, where one side was expressing one view, the other side was strongly opposed to it. Ultimately, we have to interpret the provision of the Constitution.
Exactly.
How this all came about,
This
that's
is
all
an
that we are.
aim of
Civil, you also referred to certain
I
documents.
mind, Malad, this going on, but I mean,
That's all right. These documents give us some
That's right.
air of the background,
I-
of different perspectives to the
Lord,
background.
several new facts were stated. I didn't object because I didn't want to trivialize the dialogue. This is the Constitution. When we are
Etc. Please proceed.
So kindly come to page 44.
If I not can be read in this.
Yes, sir. Lord, 43 bottom. In the course of discussions regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also.
So you are reading page?
44.
Page 43, last date, my lord. This is Constituent Assembly debates, CCD, my lord, document volume 8, PDF. My lord. I've quoted for your lordship's easy reference.
Just put back.
In the course of discussion regarding federalism in India during the Constituent Assembly, Jaspat Roy Kapoor, representing United Provinces, commented, I only wish that Kashmir should also have been brought in on the same level as other states, but unfortunately, much to our dissatisfaction and chagrin, if I may say so, this would not be done. This is a delicate subject and I'll not say anything more on this. But please read this now. This is very, very important, and in my respectful submission, the answer, my lord, lies here. what happened to Jammu and Kashmir, its sovereignty, external, internal, my lord, the difficulty is the petitioners are confusing, in my understanding, internal sovereignty with autonomy. External sovereignty, my lord, nobody can dispute that it is with the Union of India. Internal sovereignty in the facts of our case and in the constitutional structure which we have accepted would mean autonomy of the federating units. And which autonomy is there with every state? There are
It's actually there with every institution.
every institution is autonomous. So that's not
I mean,
internal.
we have the autonomous authority to decide a constitutional issue.
Commission.
But we can't say that internal sovereignty rests with us. Yes. We are an independent autonomous institution under the
They are
Constitution.
confusing the word autonomy with internal sovereignty. There is no internal sovereignty.
Except that, Mr. Solicitor, to paraphrase their argument fairly, what they are saying that, look, we gave up external sovereignty, there's no doubt about it. They say that we have acceded to the Indian Union, that's irrevocable. But they said that the course of events, the adoption of 370, would indicate that while there was a giving up of external sovereignty, a modicum of internal sovereignty, which was exercised by the then Maharaja, that was not ceded to the Indian Union. That seems to be the line of
submission. And my respectful.
And therefore, they are relying on various judgments of our court to indicate Indira Nehru Gandhi versus Rajnayan, to indicate that sovereignty has an external component, it has an internal component also.
Different context, but I'll assist your lordships on that.
By and by, in your turn, you can explain
Yes,
that
yes.
that line of. We are really on the list of dates. You can go ahead. Yes.
25th 11/1949, Yuvraj Karan Singh issued a proclamation for the state of Jammu and Kashmir. I have given the pagination, by which he declared and directed that Constitution of India, shortly to be adopted by the Constituent Assembly of India, govern the constitutional relationship between the state and the contemplated Union of India, and shall be enforced in the state by him, his heirs and successors, in accordance with the tenor of its provisions. The same proclamation is worth quoting in full. Whereas with the inauguration of the new constitution for the whole of India, now being framed by the Constituent Assembly of India, the Government of India Act 1935, which now governs the constitutional relationship between this state and the Dominion of India, will stand repealed. Your Lordships may kindly recall the instrument of accession was under Government of India Act and subsequently Independence Act. And whereas in the best interest of this state, which is closely linked with the rest of India by a community of interest in the economic, political and other fields, it is desirable that the constitutional relationship established between this state and the Dominion of India should be continued as between this state and the contemplated Union of India, and the Constitution of India as drafted by the Constituent Assembly of India, which includes duly appointed representatives of this state, provides a suitable basis for doing so. I now hereby declare and direct that Constitution of India, shortly to be adopted by the Constituent Assembly of India, shall, but please mark this, this is where, my lord, they are highlighting and I will have to meet with, insofar as it is applicable to the state of Jammu and Kashmir, govern the constitutional relationship between this state and the contemplated Union of India, and shall be enforced in this state by me, my heirs and successors, in accordance with the tenor of its provisions. That the provisions of the said constitution shall, as from the date of its commencement, supersede and abrogate all other constitutional provisions inconsistent therewith, which are at present in force. This is beyond any instrument of accession or merger. This is accepting supremacy of our constitution and surrendering the sovereignty to the constitution, where the sovereign is we, the people of India. No.
Of course, when he made this proclamation on 25th of November 1949, this is on the same day as Dr. Ambedkar's last address to the Constituent Assembly, the famous address to the Constituent Assembly. So by this point of time, the entirety of the constitution had been formulated,
Including 370
right?
in
Including
one.
370.
And Article 1.
Therefore, when he makes this proclamation in the light of 370, which also is before him,
Correct.
right? There can't be any doubt about that.
There cannot be any doubt. I bow down. And he is also very clear that what he is doing, at what stage and under what statute, what constitutional mechanism which is temporarily provided. The said proclamation is not only beyond the instrument of accession, your lordships can skip that, I orally said. Two, the preamble to this proclamation shows that it was based on the conviction that the best interest of the state required that the constitutional relationship established between the state and to Dominion of India should be continued as between the state and the contemplated Union of India. And it refers to the fact that the Constituent Assembly, which had formed the Constitution of India, included the duly appointed representatives of the state, and that the state constitution provided a suitable basis to continue the constitutional relationship between the state and the contemplated Union of India. At this juncture, the Constituent Assembly of Jammu and Kashmir was not formed. However, it is important to note that the princely state, through its ruler who had the authority to surrender the sovereignty of Jammu and Kashmir to the Union of India and made it specifically enforceable in the state, including Article 1 thereof, could never have thereafter formed a Constituent Assembly for his state, which would be a plenary Constituent Assembly, which can create a document having the sanctity and sovereignty of the Constitution of a nation in which the state merged. It was merely an act providing for internal governance of the state, which was an integral part of the sovereign, that is Indian dominion. But my respectful submission is that Constituent Assembly of Jammu and Kashmir, which formed subsequently, was not a plenary Constituent Assembly the way we had our Constituent Assembly, because by that time the sovereignty had already merged. There cannot be two constitutions. There cannot, and therefore, my lord, I am saying that the sanctity of that document, which we call Constitution, is nothing more than an act of legislation, and I'll substantiate that. But note 4. This furthers the point that the words Constituent Assembly in Article 370, sub-article 3, can be read only as Legislative Assembly, even without the aid of Article 367. Apart from this,
this will require a little clarification.
Yes, yes, but
This will require a little clarification. At this stage, we are not saying anything, because when we talk about Article 370, including the explanation which is added, which is
separate submissions,
that will require clarification.
But I'm conscious this is not the best point where I can justify the substitution.
We are not stopping you at this stage because you're going on facts.
This is not the best point on which, my lord, I would be able to justify substitution of a defunct Constituent Assembly with legislature. I'm not, my lord, joining issue with it. I have other set of submissions on that. At this stage, my lord, this is the perception, my lord, which I am presenting for your lordship's consideration. Now, my lord, kindly come to 26/11/49. The Constitution of India is adopted. But the rest I can.
So, Mr. Solicitor, as apropos what fell from Brother Justice Sanjeev Khanna, we are not engaging in a dialogue with you on any of these notes right now, because we take it that you will be arguing these aspects independently later on.
I just want to draw.
So, right now we'll run through the list of dates with you. So, we have a broad drift of your analysis.
I just want to point out broadly.
But we take it that you're going to take up each one of these strands later and argue them independently.
Have,
then we can, so instead of asking you any of our doubts right now, we'll reserve it to when you go into the themes themselves. Right now, we can just run through the list of dates.
What I intend for assisting your lordships, the way is this, my lord. After this, my lord, I'll show how the Constitution, how 370 worked till 2018, and some of the things are really shocking. And, my lord, I want your lordships, my lord, to know about, because practically, two constitutional organs, state government and the president, in consultation with each other, can amend any part of the constitution the way they want and apply it to Jammu and Kashmir. For example, I'll elaborate on this. Please mark this. the preamble of Indian Constitution was made applicable to Jammu and Kashmir by way of a constitution order under Article 371B in 1954. Thereafter, in 42nd and 44th Amendment, the word socialist and secular came to be added. That was not made applicable till 5th of August 2019. Jammu and Kashmir Constitution was not having either the term socialist or secular. And I will show the devastating effect it would have if this constitution, which according to me is nothing more than a legislature, would not have been repealed the way we have done. I'll explain the procedure which we have followed. I must satisfy your lordship's conscience. Your lordships have very rightly flagged that ends may not justify the means, but I'll justify the means also. They are constitutionally permissible means.
Eventually, when you argue that this is really not a constituent assembly but a legislative assembly in its original form, you'll have to answer how this squares up with clause 2 of Article 370, which specifically says the constituent assembly formed for the purpose of framing the constitution of that state.
Correct. I have to answer.
That is because there's a textual answer which may militate against your line of approach on that.
Yes.
Anyway, we'll discuss that later on because.
Kindly come to page 47. So this is a new point. Now, first constitution order comes. I think
you can continue on
Monday
morning.
Well, since your lordship is hearing this matter on Monday, we had some commitments. Your lordship will pardon me for some.
Certainly, yes, of course.
But I didn't know about this.
Monday running around in
no. Never.
You can't.
Never, my lord. I am before the constitution.
Yes.
No way in the world.
Out of question. I would not make any question. Right.